Hi, I'm Anitra Cassis, and thank you for joining us for the last of our 5-part What to Expect series. Today, we'll be discussing what to expect in the initial stages of regulation best interest. But before we get started, there are just 2 preliminary matters. You will see a question box on the portal where you will be able to send us questions at any point during the presentation, and we will try to answer them as we go along. And if we run out of time, somebody from McGuire Woods will follow up with you afterwards to answer those questions. And of course, you're always free to ask us questions after the presentation by contacting any one of us. With respect to CLE, we've been seeking CLE credit for all 5 of these webinars, and I believe you've given your, if you'd like CLE credit, you've given your information during the invitation process, but if you forgot to fill that out and you would like CLE credit, feel free to contact us and we'll make a note of that. As I said, I am Anitra Cassis. I'm a partner in our Richmond office and the former co-chair of our broker-dealers and investment advisors industry team. I focus on regulatory counseling and defense of broker-dealers, investment advisors, and banks in their trust departments when they have securities law issues. I was previously with the SEC's Division of Trading and Markets, or Market Reg, as when I was there. And I'm joined by 2 of our colleagues from the broker-dealer and investment advisor industry team, Alex Madrid and Aline McCullough. And as you can see, we all have A names, so you can refer to us as the A team for short. Alex is a partner in our Pittsburgh office, and his practice principally focuses on representing financial institutions, including broker-dealers, in arbitration, litigation, and regulatory investigation and enforcement matters. And Aline is a senior associate in our Raleigh office, whose practice focuses on financial services, regulatory, and private equity matters. And she works for both U.S. and non-U.S. investment managers, broker-dealers, and funds on matters under the Advisors Act, the Investment Company Act, the Commodity Exchange Act, and FINRA rules. And she also is on the business side in debt and corporate matters in our private equity group. Well, I think everyone on this that has joined us today likely knows that this has been a long, probably road is the wrong word, and roller coaster is a more appropriate term here to get us to this point. I looked back at the SEC staff study on investment advisors and broker-dealers, and that was almost 10 years ago in January. It was published in January 2011. There's been lots of starts and stops, and of course, lived through DOL and the states being actively involved in this area, and we continue to be on those paths as well. And so this is not just the end, but at the beginning, and we've had about a month now of implementation of Reg BI. I haven't heard, or we haven't heard yet of any exams from our clients in covering regulation best interest, but if any of you have had that experience and would like to share any of your insights through the Q&A box, I'm happy to share them with the group. But, we thought this would be a good time to, just a month in, to summarize what the industry and what we've been hearing from our clients on the implementation of Reg BI and what we might expect in the inevitable examinations, upcoming examinations. Today, we're going to cover who regulation best interest applies to, the obligations under Reg BI, overview of Form CRS, regulation best interest liability, the exam requirements that the examiners both in webinars and in writing have put forth some of their expectations in what we are likely to see in the examinations. The use of the advisor names for broker-dealers, and then, of course, the companion releases regarding an investment advisor's fiduciary duties and the exclusion for broker-dealers from the definition of an investment advisor and those interpretations. Who does regulation best interest apply to? Hopefully you've all figured that out by now, but let's just go over it. We have it establishes a best interest standard of conduct for broker-dealers and their associated persons when they make a recommendation to a retail customer of any securities transaction or investment strategy involving securities, including recommendations regarding types of accounts. So a lot of us in the broker-dealer industry have a long history with what a recommendation is, and I think that SEC and its staff have stated basically it's no different here. It's going to be a facts and circumstances determination of whether you've made a recommendation. But the key here is use of recommendation, and I think there's some presumptions that apply, which we'll get to. But as part of the rulemaking package, the SEC also adopted new rules and forms to require both broker-dealers and investment advisors to provide Form CRS, a brief relationship summary to retail investors. And then the SEC also published interpretations concerning the investment advisor's current fiduciary duty, standard of conduct, and the solely incidental prong of the broker-dealer exclusion from the definition of an investment advisor in Section 202A11 of the Advisors Act. I think retail customer here is obviously important in identifying who your retail customers are to make sure we're appropriately applying the standards. It's defined as a natural person or legal, it's the person's legal representative who, A, receives the recommendation of any securities transaction or investment strategy involving securities, again, from a broker-dealer, and we'll talk about capacity issues in a second, and uses that recommendation primarily for personal, family, and household purposes. Use, in the proposing and adopting release in the FAQs, it talks about when a retail customer uses a recommendation. And there's three sort of situations that they outline of when it's presumed to use a customer uses a recommendation. First, they open a brokerage account with the broker-dealer, regardless of whether there's any compensation involved. Second, the retail customer has an existing account with the broker-dealer and receives a recommendation, again, regardless of any type of direct or indirect compensation that may result from that recommendation. And third, a broker-dealer receives or will receive compensation directly or indirectly as a result of that recommendation, even if the customer does not have an account at the firm. So from that standpoint, I think those are fairly familiar concepts in this industry. Personal, family, or household purposes obviously has been used in the past. So I think they're really building, of course, on concepts that are already out there in the industry, and then drilling down to try to make sure we understand when Regulation BI applies and when the other types of standards of conduct in the investment advisors or standards of conduct for banks and other financial industry participants might apply rather than Regulation BI. Before we get to that, just focusing on what is, I think, a securities transaction. Transaction is probably fairly straightforward, but the investment strategy, the SEC and its staff wants to make it very clear that they will interpret that term, investment strategy, broadly, and it includes, of course, account recommendations. And I've just pulled some quotes from the release in the FAQs as to what their expectations are with respect to account recommendations, securities account types generally, as well as recommendations to roll over or transfer assets from one type of account to another. And then the type of securities account recommended is an investment strategy that has the potential to greatly affect retail customers' cost and investment and return. So looking at all types of the features, products, and services associated with that type of account and determining whether those features, products, and services are actually in the best interest of that particular retail customer at the time the recommendation is made. So the capacity interest issues with who in applying Regulation BI, I think are interesting because I think there's a long history in the securities industry of dual-hatted or multiple-hatted registered representatives, investment advisor representatives working for a bank, a futures commission merchant. I mean, there's a lot of crossover in this industry, and dual-hatted registration issues, supervision issues, reporting issues. All of those have, certainly come up long before Regulation BI, but it adds a complication to the standard because they're similar, but they're definitely different, right, than an investment advisor. Certainly banking regulations, Commodities Exchange Act regulations, those types of things, and really determining at the time the recommendation is made when what capacity that person is making the recommendation. And it's critical to follow that chain of thought for these dual-hatted or multiple-hatted persons. There's a lot of discussion in the proposing and adopting release about the capacity issues because I think there is a lot of concern over confusion. The SEC recognized that there's special interpretation issues for these dual-hatted and multiple-hatted persons. And in response to commenters' continuing concerns, the SEC provided additional clarification and guidance in the adopting release and the FAQs. They're trying to make it very clear that it does not apply to advice provided by a dual registrant, a registrant that's both a broker-dealer and an investment advisor, when acting in the capacity of an investment advisor. And where, similarly, right, where your financial professionals are also duly registered, if you're making an account recommendation to a retail customer, whether Reg BI applies or the fiduciary duty under the Advisors Act will apply will depend on the capacity in which the financial professional making the recommendation is acting at the time the recommendation is made. So, you need to, they said that the SEC has said that you need to make this evaluation taking into consideration when it comes to account recommendations, the spectrum of accounts that you offer, and both brokerage and advisory taking into account any eligibility requirements and not just brokerage accounts. So you have to look at, if you're dual-hatted, you have to look at the full spectrum of accounts available across the firm. If you're only, however, an associate person of a broker-dealer, you do not need to consider advisory accounts and sort of making a recommendation to the other side of the house. You just need to take into consideration only brokerage accounts available at your firm. Before we move on to the next topic, I just want to raise a similar issue because we do have a lot of clients that have referral relationships with affiliated banks that have referral relationships with either affiliated or non-affiliated broker-dealers. And we had a question arise from a bank client that had dual-hatted people who are registered with their affiliated broker-dealer and also act in a bank capacity. So not necessarily in a retail capacity, but in somehow they provide services inside the bank. They're relationship managers for the bank, and they make referrals to the trust department. And they wanted to understand what their obligations are, given that they all are sole registered representatives of the broker-dealer. My view, which I believe is correct, is that at the time they're inside the bank and making a recommendation to the bank's trust department, which is regulated primarily, the functional regulator or the banking regulators for that trust department, and they're accepted from the definition of a broker-dealer in compliance with those conditions under 3A4. But if they're making that recommendation in the capacity as a banker, which under the facts given to us, I believe that they were, Regulation BI, in my view, does not apply to those recommendations. So it again is important to do it at the point of time of the recommendation and make that capacity determination. So I will turn it over now to Alex Madrid to discuss regulation best interest obligations.
Thanks, Anitra. So before we can get into what we can expect as firms implement Reg BI, wanted to provide just a brief overview of what the regulation entails. While Reg BI declines to expressly define best interest in the rule text, it does provide for 4 specific component obligations that broker-dealers must follow. Those are the disclosure obligation care obligation, conflict of interest obligation, and the compliance obligation. And just to walk through each of those very quickly, first, the disclosure obligation requires the broker-dealer at or prior to the time of recommendation to provide a written disclosure setting forth, quote unquote, all material facts relating to its relationship with the retail customer, including but not limited to fees and costs, conflicts of interest, and scope of services. Second, the care obligation requires the broker-dealer to have a reasonable basis to conclude that a recommendation is in the quote unquote best interest of a retail customer based on the customer's investment profile. This is a heightened standard compared to FINRA's prior suitability rule, Rule 2111, which required only that a broker-dealer must have a reasonable basis to believe that the recommendation is suitable. Third, the conflict of interest obligation requires broker-dealers to identify and either disclose or mitigate any conflicts of interest associated with the recommendation. It's worth noting that Reg BI doesn't require that recommendations be made without regard to the broker-dealer's own financial or other interests, and Reg BI does not per se prohibit a broker-dealer from making recommendations where conflicts of interest are present. Rather, the SEC in its rulemaking recognized that there are conflicts of interest that are, quote, inherent in the broker-dealer business model, as there would be in any principal-agent relationship. And Reg BI permits these types of inherent conflicts so long as they are adequately disclosed. And that brings us to the fourth and final obligation, which is the disclosure obligation, requires broker-dealers, the compliance obligation, which requires broker-dealers to establish policies and procedures reasonably designed to achieve compliance with Reg BI. Having provided that overview, let me send it back to Anitra to provide an overview of Form CRS.
Thanks, Alex. Just briefly, obviously, everyone has, for the most part, hopefully filed their Form CRS already with the SEC and made it publicly available on their website. And I think the delivery obligations to investors and to your current and prospective clients is ongoing here. But so obviously Form CRS is, I think, building upon the Form 80B disclosure obligation for investment advisors, but in a shortened form. It's a relationship summary, and it's designed to promote effective communication between the broker-dealer and its retail customers. Like Form 80B, it is a narrative. It's supposed to be in plain English and easy to read, and you are supposed to follow the instructions very carefully, the Form CRS instructions very carefully, so that investors pull it up and are really comparing apples to apples here. That's what it's designed to do, so that they can get a good sense of the products and services, conflicts of interest, other disclosure issues of one broker-dealer A with broker-dealer B. It is short, as you know. It's supposed to be 2 pages. If you're a dual registrant, the maximum is 4 pages. So I just wanted to highlight the OC risk alert that was published in April of this year. OC has said that the initial exams with respect to Form CRS will likely focus on delivery and filing. Has it been filed with the SEC? Is it on your website? Evaluate the process for delivery to existing and new retail investors, and then review your policies and procedures to assess whether they effectively address Form CRS filing and delivery requirements. With respect to content, of course, I think they're going to make sure that it is narrative and in plain English and accurately follows the instructions, includes all required information. And of course, under your anti-fraud obligations, it contains true and accurate information and does not omit any material facts necessary in order to make the required disclosures in light of the circumstances in which they were made, not misleading. And that's where you're really right. That's just like Form 80B. I mean, we may get deficiencies in exams on Form 80B, but what they're really looking for is content disclosures about your conflicts of interest and your other required disclosure obligations, and whether those are adequate disclosures. Formatting, of course, that it's formatted in accordance with instructions, updates how and whether a firm updates and files within the required deadline, 30 days, same as Form U4, primarily as Form U4 and Form 80B, after any information becomes materially inaccurate, how and whether the firm communicates these changes to investors within the 60-day timeline, and the firm's process for highlighting to retail investors the most recent changes and including an exhibit highlighting or summarizing those changes. And then record keeping, are you in compliance with your delivery and record keeping obligations? Alex, you're going to discuss regulation best interest liability.
Yeah, as the litigator on the panel, I felt we would be remiss if we didn't at least touch on some potential areas of litigation liability, although that's not the principal focus of our presentation today. I did want to just briefly address a few kind of high points. First, in its final rule release, the SEC was careful to note that Reg BI does not create any new private right of action. That said, those of you who deal with customer complaints know that most retail customer claims are brought as FINRA arbitrations, and claimants in that forum routinely allege violations of securities laws and FINRA rules as causes of action. So we can expect similarly alleged violations of Reg BI, even though it does not create its own private right of action. While there will likely be disputes with retail customers regarding whether they received timely, full, and fair written disclosures under the disclosure obligation prong, I think it's more likely that the care and compliance obligations will be the ones that are litigated more frequently. And I look particularly to the heightened standard of care that Reg BI creates. As I mentioned earlier, it requires the broker-dealer to have a reasonable basis to conclude that a recommendation is in the best interest of a customer based on the customer's investment profile. And we view that as a heightened standard, and the industry does as well, to the prior suitability rule, which required only that the broker-dealer have a reasonable basis to believe the transaction is suitable. So this heightened standard of care is likely to come into play in a couple of different ways. Firstly, both the FINRA arbitral forum and courts have looked to the suitability rule and will probably now look to Reg BI to determine, what constitutes the standard of care when assessing claims for negligence or similar types of claims. It's worth noting, and we discussed this quite a bit last week if you were able to join us, we expect the market volatility that occurred as a result of the pandemic to lead to a lot more suitability claims. And those claims become all the more difficult to defend if you are forced to defend them under this new heightened standard of care. One area I did want to talk about, although it's not represented in the slide here, is something that we've been talking to clients about recently with respect to reasonably available alternatives. In its release, the SEC took the position that a broker-dealer should consider reasonably available alternatives as part of having a reasonable basis to conclude the recommendation is in the best interest. The SEC was careful to say that Reg BI does not require evaluation of every available alternative or the recommendation of the single best of all possible alternatives that might exist. Nevertheless, we're already seeing disputes arise over whether there was an appropriate comparative assessment of reasonably available alternatives, as well as whether the broker-dealer had adequate policies and procedures for compliance with this obligation. Another point that I wanted to quickly make with respect to potential new pain points, liability points, are implicit hold claims. Reg BI, like FINRA's suitability rule, doesn't impose a duty to monitor a retail customer's account. However, if a broker-dealer agrees to provide the retail customer with ongoing monitoring, then Reg BI does apply to recommendations made as part of that ongoing obligation. And Form CRS requires broker-dealers to disclose whether or not they will be monitoring on an ongoing basis. So the mere fact that this is now a required disclosure may lead more broker-dealers to agree to offer that ongoing monitoring. If a broker-dealer agrees to monitor an account, then Reg BI applies to situations where the broker-dealer does not communicate any recommendation to the customer. So essentially, if the market is dropping and your broker doesn't call you, the SEC said that can be interpreted as an implicit recommendation to hold. So obviously in the current context where we've experienced such volatility, customers may claim their brokers should have contacted them or contacted them earlier about repositioning their portfolios at the commencement of a market downturn. As part of this claim, customers may argue their brokers agreed to monitor their accounts and thus were required to communicate with them about market events. The point that we're making with respect to all of these potential pressure points is that the key to defending these claims is really contemporaneous documentation. The broker's record keeping of their interaction with clients. Brokers will need to be able to show, for example, with respect to an implicit hold claim, that they never agreed to provide ongoing monitoring, or that they were in fact in regular contact with their clients at this time during the time in question. So, the real point here that we're making is, documentation has always been key, but is now even more so. Contemporaneous documentation of communications with customers, of analysis of reasonably available alternatives, of the determination that a recommendation was in the customer's best interest. All of those, all of that documentation is really going to be needed to defend these kind of potential new avenues for liability under Reg BI. So having sufficiently covered the litigation aspect, I'd like to turn it now over to Aline to discuss examinations.
Thank you, Alex. And it is important to note that one of our attendees has actually pointed out to us that firms are beginning to get information requests and undergo exams in connection with Reg BI and Form CRS implementation. So this is no longer something that is theoretical, but federal regulators have begun reaching out to firms and looking for information and documentation in this regard. So that makes this even more timely. In response to industry pressure to extend the Reg BI and Form CRS deadlines in light of the COVID-19 pandemic, we saw the SEC repeatedly emphasize the importance of this regulatory effort and its investor protection goals. You can therefore expect regulators to be looking through this investor protection lens when conducting the initial Reg BI and Form CRS exams. Logistically, you can expect regulators to request various documentation regarding Reg BI and Form CRS, including information regarding related policies and procedures, expense disclosures, compensation of associated persons and related incentives for an associated person to place their own interests ahead of the interests of the retail customer, and risk assessment and suitability analysis processes. We have learned actually during this presentation that SIFMA has been circulating an information request that appears to have been received by a firm recently from the SEC with quite a number of requests relating to Form CRS and Reg BI. The information requested included various lists of retail customers and products sold to those customers, as well as copies of schedules or fees charged to retail customers and related disclosures. So this is all very much in line with what we've been expecting regulators to do, and frankly what the regulators have been stating they'll be looking for, and it seems pretty consistent with their overall goals with respect to these two initiatives. The good news there is that a lot of this will not come as a surprise, and the regulators aren't apparently trying to hide the ball in any way. In that vein, you can expect regulators to be looking at your Reg BI and Form CRS compliance with an eye towards good faith compliance and an understanding of the added challenges that all firms have faced from COVID-19. The initial exams that focus on Reg BI and Form CRS will be an education for regulators, and you can expect that they're seeking to gather information on best practices, common questions, and common challenges. So you can expect that you'll be receiving and invited to give information about challenges that you faced and should be prepared to discuss those with regulators, and particularly to discuss the way that your implementation of these new requirements has been impacted by the COVID-19 environment. Since we've seen the SEC and FINRA give so many different accommodations and pieces of guidance and relief from COVID-19, we would expect some sympathy provided to these challenges, provided that you have indeed been pursuing good faith compliance efforts. In a statement confirming the June 30th Reg BI and Form CRS deadline, Chairman Clayton noted that in meeting their respective obligations under Reg BI and the Advisors Act, broker-dealers and investment advisors should be reviewing their operations to be sure that they are making recommendations or providing investment advice to retail investors that is in those investors' best interest. Not a surprise there. He did note that there are 4 areas where registered investment advisors and broker-dealers may want to particularly focus when making recommendations or giving advice to retail customers. Those 4 areas were rollovers and withdrawals from 401k and other plans, complex or risky products, COVID-related investments, and special purpose acquisition corporations and other structured investment vehicles. In preparing for potential exams, advisors and broker-dealers should consider their policies, procedures, and training measures in place with respect to these types of securities and or transactions in particular. Notably, while the SEC and FINRA have indicated that enforcement actions with respect to Reg BI will unlikely be initiated within the first 6 months of effectiveness, we would expect them to pursue any non-Reg BI violations that may be uncovered in connection with a review of Reg BI-related materials. This would include, most notably, perhaps, suitability. We are also expecting certain states to be aggressive in reviewing for Reg BI compliance in connection with their own fiduciary, statute, and regulation reviews. And we have no indication that the 6-month hands-off approach that the federal regulators appear to be adopting for the first 6 months would similarly be adopted by the states. I'll now turn it over to Anitra to discuss one area in which we've gotten a lot of questions in connection with the implementation of some of Reg BI.
Thank you, Aline. I think the advisor name, issues have likely already been vetted, given the compliance date of June 30th. But, we just did want to highlight these issues in case there are any sort of outstanding or still trying to work through the exceptions. The adopting release, of course, noted that the SEC would presume that the use of advisor with an E or an advisor with an O by non-dual registrant broker-dealers to be a violation of the capacity disclosure requirement. There was initial confusion in the industry regarding the SEC stance, and so in the FAQs, they provided some clarification regarding this name issue, and that, absent special circumstances, which they set forth a little bit in the FAQs, and arguably you could overcome that presumption. It's definitely just clearly discouraged and probably an easy enforcement action if you do continue to use that name. the types of special circumstances that they highlighted in the FAQ is if you are, for example, something that is providing, an entity that's providing something other than investment advice services to retail customers, for example, a municipal advisor, a commodity trading advisor, or an advisor to a special purpose vehicle or special entity. If there are other capacities that the broker-dealer engages, types of business that they engage in outside of the context of investment advice to a retail customer, they may, in their discretion, use the terms advisor and advisor. I think my takeaway certainly of reading those FAQs and thinking about these issues, prior to the compliance date, again, it's easy enough to search to see. I think it's a pretty difficult burden to overcome in using the name. We briefly had some client questions. We briefly considered whether it would be permissible to leave the legal name but use a DBA name that did not contain, if the legal name already contains the term advisor or advisor, leaving the legal name, not jumping through the hoops to change the legal name, and then instead using a DBA that does not contain those presumptively prohibitive terms, and putting that on all marketing materials, emails, etc. We ultimately concluded not to go that route because from a disclosure issue, presents another problem with the disclosure issue, right? Anytime you use a DBA, you have to, typically from a disclosure standpoint, it'd be a violation of your obligations not to list that the name of the registered entity, and then for under FINRA rules linked to, Form CRD. So ultimately, one way or another, you would likely have to use the full legal name somewhere on the document of the broker-dealer, and that's going to bring us right back to presumptively prohibitive use of that term. So ultimately, we did not go that route, and they changed the legal name. But it was something worth considering, and certainly if you have any continuing issues, we're happy to discuss those. So I will turn it to our final part of our presentation back to Aline to discuss the companion release on investment advisor fiduciary obligations, their standard of care, and the interpretations of the broker-dealer exclusion from the definition of an investment advisor. Aline?
Sure, thanks, Anitra. As Anitra mentioned, simultaneous with the adoption of Reg BI, the SEC also approved two pieces of guidance in the investment advisory regulatory sphere. We've gotten a number of questions about these, and they seem to have been, if not at front of mind with everything that's been going on, of interest and informative to people. So we wanted to make sure that we touched upon them and made sure that you were aware of them. In the first piece of guidance, the SEC provided some clarification as to when a broker-dealer's activities may qualify under the broker-dealer exclusion from investment advisor registration. This exemption generally exempts a firm from investment advisor registration when the broker-dealer's activities are, quote-unquote, solely incidental to its broker-dealer, when the broker-dealer's investment advisory activities are, quote-unquote, solely incidental to its broker-dealer activities. Among other things, in this guidance, the SEC staff indicates that broker-dealers who have long-term investment discretion will unlikely be able to rely on the broker-dealer exclusion. Firms who have historically relied on this exemption from investment advisor registration may want to revisit their exemption analysis to ensure no adjustments are required based on this guidance. While it's not necessarily a shift in what the SEC has said previously, there is some additional detail in the guidance that may not have been apparent when you were conducting your original analysis. The SEC also issued guidance that generally expands upon prior SEC staff guidance regarding an investment advisor's fiduciary duties. The SEC emphasized the need for advisors to consider their fiduciary duties in the context of its relationship with and situation of particular clients. So, for example, your fiduciary duty may require disclosures to retail customers that you would not have to necessarily make to a more sophisticated institutional investor. This is fairly common sense. Additionally, the guidance provides more detail regarding an investment advisor's duties of care and loyalty. With respect to an advisor's duty of care, the SEC stated that the duty of care includes, among other things, the duty to provide advice that is in the best interest of the client, the duty to seek best execution of a client's transactions where the advisor has the responsibility to select broker-dealers to execute client trades, and the duty to provide advice and monitoring over the course of the relationship. With respect to an advisor's duty of loyalty, the SEC repeated its stance that the duty of loyalty requires that an advisor not subordinate its client's interest to its own. In discussing the duty of loyalty, the SEC cites various previous SEC enforcement actions and discusses particular conflicts of interest and disclosures relating thereto. In connection with Form ADV updates, advisors may wish specifically to review and consider the guidance provided in this release regarding the appropriate level of specificity, including the appropriateness of stating that an advisor, quote, may have a conflict, and considerations for disclosure regarding conflicts related to the allocation of investment opportunities among eligible clients. The use of may is something that we have seen the SEC really come down hard on over the years, and this is an area of challenge for many of our clients because it is the case that when you're trying to include as much detail about your conflicts as possible, that you want to be as inclusive as possible. And not everything that you are disclosing is something that will definitely be a conflict. However, the SEC in this guidance makes it clear that they will be standing by their stance that may should be avoided and more definitive statements should be made whenever possible. With that, we'll turn to a couple questions that we have received during the presentation, one of which it looks like is whether we have seen clients who do not yet have full-fledged best Reg BI and Form CRS compliance programs in place. We have seen clients continue to refine their policies and procedures as they start to implement the procedures and tweak them, but it will be important when the SEC and or FINRA inevitably comes in the next exam to make sure that you do have very clear policies and procedures in place that do specifically address these regulatory requirements, given that the SEC and FINRA have been so consistently focused on them and unwavering even in the face of the pandemic.
This is Anitra. Are there any other questions that we can answer for you at this time? And feel free to send them along. I think along with Elaine's point, even if the SEC and FINRA, just to reiterate it, is to, may go a little bit easier in these initial stages. The states, and some of the states, and you all have had some of the experience here, are very aggressively regulating in this area and have been for the last few years in enforcement action. So, even again, if the federal regulators and SROs are giving you the benefit of the doubt if they see that you're working in good faith to bring yourself into compliance with policies and procedures and controls regarding Regulation BI. The state examinations, several states do not believe, as you know, that this goes far enough and leaves investors open to be continuing to take advantage of in their view. We do expect those regulators may not give you that same benefit of the doubt, so to speak, and will, if they have the authority to bring enforcement action over violations of federal law, which a lot of states do, if not all states, in their statutes, will be seeking to be more aggressive in this area, from right out of the gate. I don't believe we have any other questions, but if anybody thinks of anything after the call, again, remember, please feel free to reach out to any one of us or anybody else in our broker-dealer investment advisors industry team practice. We'd be happy to answer any questions, and as we're all going on this journey together, happy to share information to the extent that we can. So, again, everybody's trying to work in good faith to comply with regulation best interest, and we're happy to be of help in any way that we can, including sharing information to the extent we are able to. So with that said, I believe we come to the end of our presentation, and we will still get CLE credit, even though we were going to give you back 13 minutes of your day. And with that, we'd like to conclude this presentation, and thank you again for your time.